Hi, this is Steve Floriston and this is Unit 10, Facilitate the Interest and Rights of Clients. This presentation is in two parts. The first includes human rights, human needs, identifying student issues, advocacy and complaints, and the second part is mostly just about work practices. There's two assessments, 10.1 and 10.2. 10.1 are the written questions. 10.2 is a case study in three parts. So, if we're looking at human rights, how are the rights of people protected in Australia? They're protected by common law, statute law, the Constitution of Australia and international law. Common law comes from previous court cases or decisions, sometimes called judge-made law. Statute law is legislation that's handed down from the Commonwealth Parliament. So human rights are protected by a combination of common law and statute law. And into these feed international law and the Constitution. So let's have a look at the Constitution. Before 1901, Australia was 6 British colonies, and we almost became, I guess, 6 separate countries, like a lot of other continents. And we were partly self-governing, but also subject to the British Parliament. At the time, people could see the benefits of a single federation or a single country, and that was mainly to do with uniform immigration laws, a single defence force rather than 6 separate defence forces, a postal service and a rail service, like a national postal service, and increased independence from England. They wanted a much greater level of independence from England. And you can see there Alfred Deakin down on the right, who they call the father of federation. He was the Premier of New South Wales at the time, and he drove much of this. And sadly, he died before it actually happened. During the 1890s, representatives from each colony, or each of these little countries, attended conventions. They decided what would be in the Constitution, they made a set of rules and laws, and they determined how the country was run, or how the country would be run. You can see some images from those years. They looked at a Bill of Rights, they looked at America and other countries, and they considered a Bill of Rights, but the colonists at the time decided, for some reason, against including a Bill of Rights in the Australian Constitution. So the Australian Constitution contains few protections for human rights. So for Federation, the Constitution was prepared. It was voted on in a series of referendums in each of these 6 colonies to accept the Constitution and to form the federation or the partnership of the colonies. And you can see the voting slips down there on the right and some of the advertisements. So the Constitution was approved in the referendums. It was agreed by the British Parliament and Queen Victoria and was passed as a British Act of Parliament in 1900, so it actually came into effect on the 1st of January 1901. You can see, I think that's what they call Centenary Square in Sydney. Very famous photo. The Constitution in Australia is called supreme law, and that is because it overrides all other law in Australia, and it can only be changed by a referendum. We do have some rights in the Constitution, and there are 5 explicit rights: the right to vote, the protection against acquisition of property on unjust terms, the right to trial by jury, freedom of religion, and prohibition of discrimination on the basis of state of residency. And you can see that that's probably not quite so relevant these days, but they were probably concerned that it would be, that some states would be discriminated against, or some people would. More recently, the High Court has found that there are a lot of additional rights that are implied or understood just by the language and the structure of the Constitution. So there are other implied rights, but these 5 are the explicit rights. Now, if we're looking at international law, and remember that international law and the Constitution feed into statute law and common law to determine our rights. So international law feeds in. Australia's got a very strong record of adopting and supporting international human rights, even though we're a very small country, a small population. In 1948, the United Nations adopted the Universal Declaration on Human Rights, and Australia played an effective role in developing this. We're a signatory, and what that means is that we've got certain responsibilities to make sure human rights are consistent. The United Nations can examine human rights conditions in Australia to make sure Australia is acting in a way that supports these laws and treaties. and the Australian government must publicly report. And community organisations can also contribute directly to the United Nations, and this is known as a shadow report. So, just any community organisation can make a shadow report to the United Nations. So these are the sort of things that we're party to: the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, Convention Against Torture, the Rights of the Child. This is a pretty important one. The International Convention on Elimination of All Forms of Racial Discrimination, then Discrimination Against Women, and then Convention on the Rights of Persons with Disabilities. We have an Australian Human Rights Commission Act, 1986, because even though we're signatory to these different covenants, these covenants aren't laws. These are not binding laws on Australian people. What happens is a country makes laws based on those covenants, and then those laws then become binding on Australian people. So those things there are the sort of things that the Australian Human Rights Commission does. So let's go back and have a look at common law again, because this is a big part of our rights, an important part of our rights. It comes from previous court cases, and they can be customs and understandings that result from previous court cases. It's a very slow, incremental process, and it usually starts off with a single decision made by a judge, and then more decisions reinforce this original decision until it becomes an understanding, something that's accepted, something which is precedent. Statute law are laws made in Parliament, so they're handed down by Parliament, and as we've already seen, these are affected by international laws or international covenants. So common law rights include these things: the right of access to courts, immunity from deprivation of property without compensation, legal professional privilege, privilege against self-incrimination, freedom from extension of government immunity by a court, immunity from interference with vested property rights, and so on and so forth. I think you get the idea of what these common law rights are. Immunity from interference with equality of religion, no deprivation of liberty, procedural fairness, freedom of speech, and so on and so forth. And these are common law rights. They come from common law decisions. So do we have human rights abuse in Australia? And the answer to this depends very much on your perspective. If you're a very wealthy person, see this fellow down there on the left or the fellow in the middle, you're very wealthy, you own your own home, you have lots of assets, well, you probably don't see very much human rights abuse. Your rights probably don't get abused very often. If you're a vulnerable person, such as a minority, an Indigenous person, a migrant from a non-English speaking background, a person with a disability, then you'll probably see that there are significant human rights. Probably not the same as some other countries, but certainly there are human rights abuses in Australia. When we look at human needs, we most often look at this triangle of Maslow: self-actualization, self-esteem, love and belonging, safety and security, physiological needs, and people these days put underneath that the need to be connected, because it seems that young people particularly have a great need to be continually connected to the internet, to phones, etc. It's interesting to think about when needs become rights. So this does happen, and if you look at the history of Australia, you'll see that over time we have had needs, and these needs actually become rights. And so if you think of things like education, or fresh drinking water, or sanitation, at one time these were all needs, and we all had these needs, but over time they became rights. We have needs and rights in the boarding residence. Student rights are protected by legislation, like rights that are in the Constitution, etc. So some of them are just our normal rights that are the same for all Australians, but others can be found in documents like the enrolment application form, advertising and promotional material. So the organisation, the boarding school, the boarding residence has made certain claims or certain promises in this material, and then they really become rights because you have a right to them because you have embraced the program based on those promises. And so they come from things like, the promotional material, the parent handbook, student handbook, any of that sort of general information provided to students and parents. And so there are also implied rights, and these are like, I guess, an implied contract with the boarder. And they're things like a safe boarding environment, privacy, confidentiality, to be treated with respect and dignity, to have informed choice, and so on. So what do we do if these are not being met in the residence? This is question 5. And, the answer to this is fairly obvious. The first thing you can do is that you can make a complaint, and you can probably make that complaint to your head of boarding or to the school principal or eventually to the school board, or you might get more serious about making the complaint. You can also remove yourself from there, so to vote with your feet, as it were. So there are quite a few options for parents and students if their rights and needs are not being met in the boarding residence. Supervisors have rights too, and there's some rights there. Supervisors have a lot more rights than that, of course, but I like to think that supervisors are treated with respect and dignity, and that they have informed choice, they have a safe working environment. How do we become aware of student needs? So this is from a student's profile, and a student's profile are things like the application form and information that's gathered after that, in any information that's attached to the application form. We become aware of a student's needs by observing students and becoming aware of specific signs, and this is why it is so important to have that, that strong relationship with young people, and to be supervising them in a way where we can see if there are specific needs. Sometimes we're told by another person, such as another student or another supervisor, or we might be advised by a parent, a nurse, or a counsellor. How do we address a student's needs? And this is very common to all boarding staff. They do this all the time, not usually in an organised manner like this, but they're doing it all the time, just like listing the needs, prioritising needs, involving others as needed, developing a strategy for addressing the needs, together making sure whether the residence has the capacity to meet the needs of the student. And I want to talk a little bit more about that in a moment, to share relevant information about options and services available, enable students to make informed decisions, and then provide the student with the resources needed. So what happens if you're not able to meet the student's needs? So this might be because the needs are outside the experience, skills or knowledge of the residential team. They're not met by the residential program, they're not catered for in the physical environment, or they're not catered for in the procedures of the residence. And we've got a tool like this. We use this tool, and this is what we call a profiling tool, and this tool is meant to be used when a student applies, and the purpose of this tool is to know whether or not the residence has the capacity to meet the student's needs. Sometimes, especially these days, we see students coming to boarding with very complex and serious behaviour needs. They may have deviant sexual behaviour, they may have health issues that are very difficult for the residents to meet. And so the residents needs to know whether or not they have the capacity to meet these students' needs. And so you can see this, just following this profiling tool down, the student's application comes in. So the school will contact the residents will contact the previous school. They look at attendance, behaviour, attitude, parent support, those sort of things. And you can use the profiling tool to develop a score. Most students that come to your residence, most students that apply to your residence will go down that left-hand side, down the right-hand side, where you do very little because it's quite obvious that they don't have any of those complex needs. If they do have complex needs, or if they've been involved in serious criminal behaviour or solvent or drug use, those sort of things, then you need to do a lot more interviewing to work out whether or not your residence has the capacity to meet this student's needs. And here is the profiling tool, and this tool is available on the website, and you're welcome to download it. The thing about this tool is that it's infinitely changeable, so you can move those numbers along. So for example, if we look at attendance, and you've got down on the left hand side we've got 60% and at the top we've got 95%. Well, you might say 80% is in the middle. That's just not good enough for us. We would want 95% in the middle. So you just move it to suit your particular boarding residence, and you include whichever of those profiles you want. So you've got attendance, behaviour, attitude, parent support, and academic standard. So what do we do to meet students' needs when those needs are different? You know, it's an increased level of need, or it's a different type of need. So you can retrain or employ additional staff. You can bring in trained external personnel. You can refer that student. So you could have the student in your residence but refer them to outside professionals like doctors, psychologists, etc. You can redesign the residence programs, examine and adjust procedures, adjust the physical environment, or you can encourage the student to move to a more appropriate residence, a residence that does actually have the capacity to meet the student's needs. All right, let's talk about advocacy. Advocacy is standing alongside a student who sometimes they're unwilling or unable to speak for themselves, to represent the best interest of students, to enable the student to retain as much control as possible over how it's carried out. And again, this is something that boarding supervisors do probably on a daily basis. You might advocate to the head of boarding, you might advocate to somebody in the school, to a football club. You're talking to these people on behalf of the student, you're representing the student. And you can see here the different reasons why a supervisor might advocate. And then we have steps, these formal steps for advocacy. But I want to talk about self-advocacy. So a student who is a self-advocate, so that is a student who advocates for themselves or represents themselves in these interactions, says what they think and feel, they speak up for the things they believe in, they know and understand their rights and responsibilities, they take responsibility for their own life, they make decisions that affect and improve their life, and they try to change the way things are done. So that's self-advocacy. And you know, if you think about it, one of the primary goals of the boarding residence should be to empower students to become self-reliant and self-determining, particularly as they move through, you know, into your upper secondary, year 11, year 12. They need to become self-reliant and self-determining. So you can support a student to self-advocate, and this will empower the student. Self-advocating should be the first option, but sometimes there are barriers. And question 9 asks, what are the barriers to self-advocacy? And these are the sort of things that are just logical. You know, when a student might be shy or fearful, they may have a lack of communication skills, and they may just lack skills to self-advocate. When do you seek a student's permission to release confidential information? So this is usually after a student has talked to you about something. So a student might have talked to you about a health issue, or it might be a mandatory reporting issue, or an abuse issue, or something like that. And you have to seek their permission then to say, look, we have to involve other people in this. You know, we have to take this further. It may also be where you need to refer the student. So where you might have to refer the student onto a psychologist or a counsellor or somebody else, and it's in those circumstances where you would need to seek permission to release that confidential information, because if the person's going to help them, the counsellor or whatever, then they will need that information about the student. I just want to talk briefly about complaints procedure, and this is also on the resources page of our website, and you're welcome to download this. Complaints should be part of our duty of care to ensure that complaints are dealt with, not overlooked. This process empowers the student, provides a record that the complaint has been dealt with, and this is likely to become part of the standards for the boarding industry as, standards are adopted and possibly mandated. So the student complaint process, this is the sort of thing that you would find in a process where forms are available in the handbook or the admin office, where they're informed about the process during induction. Students with a complaint or a grievance fills out the form and asks admin or supervisor to help fill out the form. Form goes off to the head of boarding. Head of boarding takes appropriate action to resolve it. All parties are kept informed, and then the student would sign off to indicate that they're satisfied with the resolution or action. Just want to say about this that this is a process that we should be teaching our students, because when they leave us, when they leave to go out into the world, this will empower them. If something goes wrong, they need to know how to make a complaint. They need to know how to put their side out there, and this empowers students. Thank you very much.